Hello viewers and students. This is Dr. Neharkar and I welcome you in my YouTube channel at lecture series on labor laws first. Students, in this lecture we are going to discuss the concept of layoff and provisions relating to layoff under Industrial Dispute Act 1947. Friends, firstly we must say what is the concept. The layoff is nothing but the inability of employer to provide work to his workers. So the Industrial Dispute Act provides the circumstances where the employer is unable to provide work to his workman and the reasons also. So this can be the matter of dispute. So in employee relation, it is duty of employer to provide work to his employees, and when the employers fail to provide the work to workers, then he may not pay wages to his workmen, and because of that it may give rise to industrial dispute. Therefore such condition must be properly handled. Therefore the Industrial Dispute Act 1947 provides provision to regulate the circumstances where the employer fails to provide work to his workman. Friends, we must see what is the definition of layoff under section 2 K of Industrial Dispute Act. Friends, as in general we know, layoff means the circumstances where the employer is unable to provide work to his workman. So it is failure of employer to provide work to his workman. But now we must see what is the definition of layoff that is provided under section 2 K of Industrial Dispute Act. Friends, layoff means failure, a refusal or inability of employer to give employment to the workman whose names are borne on muster roll of industry and who has not been retrenched due to or because of shortage of coal, power, raw material or accumulation of stock, breakdown of machinery or any other reasons which are beyond the control of employer. Friends, if you go through this definition you can understand. See, layoff is nothing but first thing you must understand is that the employer is unable to provide the work to those workmen who are regular workers of that industry, or who are those workers whose names are mentioned on a muster roll. And secondly, this failure is due to the reasons, due to the specific reasons which are provided by this section itself. And these reasons are shortage of coal, power, raw material, accumulation of stock, breakdown of machineries, etc. And see, all these reasons are the reasons which employer may not control. So this is the necessity to regulate such unavoidable circumstances where though employer is willing to give work to his workman but he is not able to give work to his workman due to such reason. So this section defines what is concept of layoff. Friends, so in brief we can say that if employer fails to provide work, or he refuses to provide work, or he is unable to give work although he desires to give work to his workmen whose names are mentioned on a master roll, such inability to provide the work is called as a layoff. It is called as a layoff. And friends, if you go through the definition, you can find certain essentials of layoff that we must say one by one. The first essential of layoff is there must be failure, a refusal, or inability of employer to give the work. There must be failure, a refusal, or inability of employer to give work. This is the first essential. And see, while discussing this essential, you must remind one thing, that here this act is not a willful act by the employer, or this is not the voluntary act by the employer, but he wants to give work to his workers, but due to certain reason he is not able to give work. Then second essential is that it is a failure to give work to those workers whose names are borne on muster roll of industry and who are not the retrenched workmen. See, this is the instance. Second essential provides the instance of non-employment. This is the instance of non-employment. See, the employed workers are employed there to work something, whatever the work which is allotted to them. But here, employer on particular day, he fails to give them the work. So this is the failure to give work to those workers who are the workers of industry, and this is not the failure of to give the work who are not the workers of industry or who are the outsiders. Then we must see what is third essential, and the third essential is that the failure or refusal or inability of employer to give work must be caused due to any of following reason, whatever the reason may be, but these reasons may be the reasons that are mentioned below. So the first reason is the shortage of coal, where any industry runs on a coal, so that is necessary, that may be used as a fuel in that industry. So when such coal is not available, when there is a shortage of coal, that industry could not run. So this is the first. And when the industry couldn't run, the employer can't give work to his workmen. So this is first reason. Second is shortage of power. See, this is the second thing, where due to the shortage of power, this is also one kind of reason, similar like the shortage of coal. The employer cannot give the work when there is no power, when there is no electricity, because most of machineries in industry or the manufacturing process or the different process under industry that may be run with the help of or with the aid of power. So when there is a shortage of power, the industry cannot be operated. So this is second reason where the employer is not able to give the work to his workmen. Third one is when there is a shortage of raw material, because in industry that there may be the process of converting raw material into final sellable goods. So when the raw material is not available, how that industry could produce the products? So this is third reason. Fourth one is accumulation of stock. As you know, the production that is produced in industry, that must be sold into the market. There should be demand to the products of that industry, and when the production is more than demand, then it results into the accumulation of stock. So that stock may be accumulated in the godown, etc. So at that time also that employer has to take decision to stop the production for few days or for a few time. So this is also the instance. Then next reason is the breakdown of machinery. See, due to the breakdown of machinery, the process has to be stopped, because in industry the work is done, work is dependent upon the use of machineries, etc. So when there is any breakdown of machinery, there is not possible to continue the work in industry. Then any natural calamities, there's natural calamities. When such calamity affects the working in industry, it is also one of the reason for a layoff. So that natural calamity, maybe flood, that may be earthquake or whatever, any cyclone, etc. When due to such a reasons where employer is unable to give work to his workmen, that is also a layoff, or any other reason which is beyond the control of employer. So these are the reasons. And lastly, such employers failure to give work is to the workmen who are regular workmen, and such workmen should not be retrenched, because the retrenchment is one kind of unemployment. So when any person is retrenched from the work, it cannot be called as that it is laid off due to such reason, but that person may be retrenched for whatever the other reasons. So these are the essentials of layoff. So layoff is nothing but where the employer fails to provide the work, or where the employer fails to give work to his employees, regular employees, due to the reasons like shortage of coal, power, raw material, stock, etc. Such a circumstances or such is called as a layoff. Now we must see what is the classification of layoff. See, the Industrial Dispute Act classify layoff in certain categories. So this classification is made on the basis of period of layoff. So according to the period, the layoff is classified into following categories. The first classification or first type of layoff is layoff for more than 1 hour in a day. The second is layoff for half day, and that can be layoff for day or more also. And third type is no worker can be laid off for more than 45 days. So the maximum period of layoff which is allowed by Industrial Dispute Act is 45 days. Afterwards we will see when layoff exceeds the 45 days what will be the action taken by the employer. So this is qualification. So now we must see what the procedure that employer must follow before to lay off any workman. So this procedure is provided by section 25M. So this procedure should be followed by the employer before he lay offs any workman in industry. So he cannot compel workman to stay without the work, but without this procedure. So the first this procedure prohibits employer, what section 2M of the act prohibits employer to lay off workmen without following procedure. We must see what is the procedure. See, firstly, the employer cannot lay off any worker. The employer cannot lay off any worker without prior permission from the government, except shortage of power or natural calamities. See, section 25M works as a prohibition of for layoff, and according to this section, an employer cannot lay off any workman without obtaining prior permission from the government. But this permission is necessary for two reasons, and these two reasons are shortage of power and natural calamity. Because these two reasons are not in the hand of employer, or even the employer cannot anticipate such circumstances when there may be the shortage of power or there may be the shortage of power or the natural calamity. So for these two reasons there is no necessity to obtain the permission, else the employer has to obtain the permission. Then secondly, when employer wants to lay off his workmen, then he has to make an application to appropriate government with the reasons. It means he must apply to appropriate government by using prescribed application form, and in that application he must clearly state that what are the reasons for which he is unable to give work to his workmen. Then he must give notice to his workmen at the same time when he apply for the permission. The notice should be given to workmen, to all those proposed workmen to whom he is unable to give the work. Then now it is a duty or it is a role of appropriate government whether to grant or refuse the permission. So the appropriate government may grant or refuse the permission, but before that, when the government is going to refuse any permission to employer for layoff, he must give an opportunity to employer. See, so at the time of giving permission, government may examine the necessity and the reasonability of a layoff. If government thinks that in given circumstances a layoff is necessary, then government may grant the permission. If government thinks that the there is no existence of reasons which are provided by the definition of layoff, the government may refuse permission to lay off. So whatever the decision which is taken by the government on that application, that shall be final, that shall be binding on the employer. If government refused permission for layoff, then employer cannot lay off the workmen. So the employer, when the permission is granted, shall give notice to proposed workmen to be laid off. So this can be done only when employer receives permission from the government for layoff. So when government specifically permits employer to lay off, then he has to give notice to every workman to whom he is unable to give work. Now we have to see the provisions relating to compensation. Section 25C of the Act deals with the compensation. This is the section which provides the entitlement of workers to compensation. See, because though the layoff is permitted, but that layoff should not result into total loss of wages of workers. So there should be the compensation for the loss they have to they have to face. Therefore section 25C of the Act provides that when any employee who has completed 1 year of continuous service in an industry, and if he has been laid off, then he shall be entitled to compensation for the period of layoff. It means the person who has worked at least for 1 year in that industry, and if his service is continuous for 1 year in that industry, and when such type of worker is laid off, then he must get compensation from the employer. What shall be the amount? That will be decided by the Act itself. See, so what shall be the amount of compensation? So where any and see, the compensation is dependent upon what is the period of layoff. So according to that period, the amount of compensation shall be given. So that amount of compensation shall not be same for all the types of layoff. So where the layoff is for the period exceeding 1 hour in a day or up to half day, in such circumstances the workers are entitled to get full wages for that period. So 1 hour to half day in a day, when any workman is laid for 1 hour to half day, in such circumstances that workman is entitled to get wages for the full period of layoff. So this is the first type of compensation that to be given to workman. Second quantum of compensation is dependent upon second type of layoff. So where a layoff is for the period of a day or more, in such a circumstances the workers are entitled to get mm, 50% of wages for every day of layoff. See, and this compensation is provided, the 50% of compensation is provided to protect the rights of both parties, to protect or to minimize the loss caused to employer as well as loss caused to employees. The 50% of wages shall be given for every day of layoff. And thirdly, as I have already told you, that the layoff period shall not exceed 45 days. So in no industry layoff beyond 45 days shall be allowed. And if it continues beyond 45 days, the employer enter into an agreement with the workman, and that agreement will be for a retrenchment. And when such agreement is entered between such employer and employees for retrenchment, the employee shall get the amount of compensation. So the provision is made, this provision is made to provide a relief to workmen who became unemployed without his fault, as well as this provision is made to provide a relief to employer also who is unable to give work without his fault. So then, as I have already told you, that the amount of compensation shall be given to only those workers who have completed continuous service for 1 year. But now question is how to calculate the continuous service of 1 year, and for that purpose the act provides that the the workman who has worked at least for 240 days in a year shall be termed or shall be deemed as the person who has completed continuous service for 1 year. So that person should have worked at least 240 days in the year, and this period includes his absence from the work due to any legal leaves, casual leaves, etc., medical leaves, etc. So that will not be deducted from the period of 240 days. So this period is 90 days in case of mining, 190 days in case of mining industry. So this period is less than the period which is provided in regular industries. So friends, now the employer has to follow these provisions, and now we are going to discuss the penalties under the act. And the act provides following penalties. The Industrial Dispute Act provides following penalties for layoff without permission. The employer who contravenes the provisions of act shall be punishable with punishment, and that is imprisonment up to 1 month or fine up to rupees 1000, or with both. So friends, we have discussed the concept of layoff, the procedure that must be followed before he lays off his workmen, the compensation to be paid to workmen, and penalties for penalties for layoff without permission. So friends, if you like this video, please share with your friends, and do not forget to subscribe my channel. So friends, thank you.